Business Professions and Economic Development Committee, as well as the Assembly Business and Professions Committee. The next item on our agenda today is the Bureau of the Court Reporters Board. And so if we could have the Board President, Davina Hurt, Board Chair, Rosalie Cram, Board Vice Chair, and Yvonne Fenner, Executive Director. Good afternoon, ladies, again. It was nice to chat a little bit. It's nice to see Davina Hurt here as see you've been a city council member in the city of Belmont for how long now?
Yes.
Which we're honored to have.
Hat on today.
You have a different hat on today, that's true. But it's great to see you in this venue.
Nice to see you as well. So,
yes, please proceed.
Thank you. Good afternoon, Chair Hill and members of the committee and staff. My name is Davina Hurt. As introduced a moment ago, I'm the newly appointed chair of the Court Reporters Board of California. I'm a public member reappointed by former Speaker Tony Atkins, with my original appointment by former Speaker Perez. To my right is Rosalie Cram, Vice Chair of the board. And to my left is Yvonne Fenner, Executive Director of the board. So I'll begin with an overview of our current regulatory program. In 1951, the Court Reporters Board was established by the legislature to protect consumers from unskilled practitioners. Formally, the legislature gave the board its mission to protect the public's health, safety, and welfare by ensuring the integrity of judicial records through oversight of the court reporting profession. It was understood early on of the possible dangerous ramifications of unfair or biased trials, where the record can be the difference between acquittal or life in prison. The integrity of our legal system rests on accurate records made by an impartial third party. Thus, the board carries out this important mission of oversight by testing, licensing, investigating, disciplining, and regulating court reporters, as well as recognizing court reporting schools that meet minimum state curriculum standards. In an effort to also promote access to justice, the board also administers the Transcript Reimbursement Fund, which provides free or low-cost transcripts to qualified indigent litigants. Today, there are approximately 6,850 active licensees with extensive knowledge of the law. They work as official reporters in courtrooms or in the private sector as freelance reporters who report depositions, arbitrations, among other quasi-judicial proceedings. The board itself is comprised of 5 members. The governor appoints 2 professional members and 1 public member. The Senate Rules Committee appoints 1 public member, and another is appointed by the Speaker of the Assembly. The board meets 2 to 3 times a year. Now, the board staff consists of 4 full-time employees and 1 half-time that rely heavily on a variety of pro rata services through the Department of Consumer Affairs. Making full use of these services and keeping costs at bay, we've used the Office of Publication, Design, and Editing to reformat our applications and renewal forms, as well as a variety of best practice pointers and miscellaneous publications. The board receives legal assistance from the Legal Affairs Unit and board member staff training from SOLID, DCA's training unit. SOLID has also provided facilitation services at our town hall meetings, as well as conducting strategic planning. The board is currently working with the Office of Public Affairs to develop a comprehensive communications plan in furtherance of its current strategic plan that was adopted in 2015. The board receives technical support on computer and phone systems from the Office of Information Services and fiscal and accounting support through the Budget Office. The Business Services Office provides help to the board with contracts, purchasing, facilities, and records management. The Office of Human Resources supports the board personnel needs from hiring and firing procedures through benefits management and management of the Employee Assistance Program and labor relations. I just wanted to capitalize how much we rely on the services of DCA. It's very clear with a small board like ourselves. The work that they do for us is very important. To fulfill the testing portion of our legislative mandate, the board works closely with its sister agency, the Office of Professional Examination Services, to develop a license examination that's reflective of the skills and knowledge necessary for entry level into the court reporting industry. The test is composed of 2 written knowledge tests, 1 for English and 1 for professional practice, and 1 practical skills portion. Upon successful completion of all 4 portions of the examination, a candidate applies for licensure, and once the license is granted, they may begin practice. Moving to the enforcement portion of its mission, the board receives around 100 complaints per year, mainly related to licensees' failure to submit transcripts. Concern from consumers are taken seriously and thoroughly investigated in a fair and timely professional manner by the board staff. The board has a policy of really working hard to mediate issues before they escalate, whereby very few complaints continue on to the Attorney General's office for review. Further, it's important to note that proactively, the board also works to keep licensees abreast of changing laws and regulations, as well as best practices to ensure that consumers receive an accurate transcript in a timely manner in compliance with applicable laws. It can't be said enough that consumers benefit from knowledgeable practitioners, and the board's enforcement unit benefits from keeping complaints to minimum with a proactive education measure. Protection of the consumer is also achieved through oversight of court reporting schools. There are currently 6 private schools and 7 public schools that the board evaluates in recognizing whether their program meets the curriculum standards set out in regulation. Lastly, the board is tasked with the administration of the Transcript Reimbursement Fund, which has 2 programs that will be addressed in more detail by my colleagues. I'll just highlight that it has been a valuable resource for those less able to have access during vulnerable times of litigation. And I'll just close with the fact that although the board is tasked with the oversight of the court reporting, since my appointment, it's been remarkable to understand and see how the board's work has touched so many other professions, such as judges, attorneys, and litigants. And I'll pass it on to my colleagues.
Thank you very much, Ms. Hurd. Appreciate it.
Hi, I'm going to address the first issue with the board. Again, my name is Yvonne Fenner, and I'm the Executive Officer for the Court Reporters Board. And our first issue that staff asked us to address was concerning the current license fees and whether they're sufficient to maintain the board's long-term financial solvency. And as part of the fiduciary oversight, the board closely monitors the budget, and they projected that the board would need to address a fund imbalance probably in fiscal year 2017-18. Having already implemented all of our cost-saving measures, the board looked at some options for increasing revenue. We looked at increasing examination fees, but with a relatively small number of candidates annually, even a draconian hike in the exam fee would not significantly improve the board's long-term solvency. So in January of 2015, the board decided that an increase in the license fee was necessary. However, we are currently at the statutory cap for license fees. That statutory cap was set back in the 1900s. Actually 1951, and the statutory cap wasn't reached until 2010. So the board directed staff to look for an author for legislation to change the Business and Professions Code Section 8031, increasing the fee cap from $125 annually to $250 annually. The Legislative Counsel's Office informed the board that because a portion of our license fees is used to fund the transcript reimbursement fund, the fee cap increase would actually be considered a tax, which clearly you know would require a 2/3 vote. Staff was unsuccessful in finding an author for the fee cap increase, but we have been continuing to work with consultants from both Senate and Assembly Business and Professions committees to find a solution for this dilemma. The timing of the solution is becoming critical as the funding for the transcript reimbursement fund is now in jeopardy. Business and Professions Code 8030.2 sub A prohibits a transfer being made from the Court Reporters Fund to the Transcript Reimbursement Fund if the transfer will result in a reduction of the balance of the Court Reporters Fund to an amount that's less than 6 months of our operating budget. That is projected to occur as early as fiscal year 2016-17. The TRF comprises roughly 1/3 of the board's total budget. So if we did not fund the TRF, the board would be able to accomplish its licensing and enforcement programs for several more years. However, since 1981, when the TRF was created, we've provided over $8.5 million in transcripts to those in need. The board has been working closely with legislative staff to find a workable solution to the license fee cap issue in order to maintain not only the access to justice provided by the TRF to the most vulnerable of consumers, but also to continue the board's other mission-critical programs, the ones we've already mentioned. In our search for an author to increase the fee cap, every legislator's office we contacted said they would support the bill. However, none were willing to author the bill. So we respectfully ask the oversight committees to help us with an author for that bill. Which leads us into the second issue, which is should the legislature amend the $300,000 that goes to the transcript reimbursement fund, unless reserves are too low. Currently, under Business and Professions Code 8030.2, a transfer of $300,000 from the Court Reporters Fund to the Transcript Reimbursement Fund happens at the beginning of each fiscal year. It's an automatic transfer. It would be helpful to the board if it would give us greater flexibility if that language were amended so that it would allow for transfers as needed up to $100,000 or up to $300,000 per fiscal year. That way, we don't have to transfer the full amount. If it's not expended, then transfer it back. It just makes it cleaner if we can transfer it over, say, $100,000 at a time up to the cap of $300,000. That would give us the most flexibility. Funded completely from court reporter license fees, the TRF was set up to assist qualified indigent litigants with transcript costs. And the fund now has 2 programs. The main fund, as I said, was originally set up in 1981, and it requires indigent litigants to have a pro bono attorney to handle the case. The pro bono attorney actually then vets the financial solvency and certifies to the board that that litigant meets all of the indigent requirements set out in law. In 2011, a 2-year pilot project was developed to allow pro per litigants, or litigants that represent themselves, access to the fund. The pilot project was a success, and it's now a permanent part of the TRF. However, that the pro per program is capped at $30,000. And since its inception, that cap has proven to be too low for the demand. And it's not uncommon for the funds to be completely allocated only 3 months into the funding year. This requires applicants to wait well over a year for reimbursement. This shortage of funds became so severe that it impacted the schedule of litigation in courts, and a rule of court was adopted requiring litigants to provide provisional approval from the TRF within 90 days, find an alternate method of obtaining the transcripts, or they had to forfeit their cases. So it has quite the impact on the court system. We're proposing one method of increasing access to the Pro-Per program without increasing the overall transfer to the TRF, and that's to leverage using the calendar versus the fiscal year. There's a difference between the two programs. The main fund, or the pro bono program, runs on a fiscal year. The Pro-Per program runs on a calendar year. So if the total program is capped at $300,000, of which $270,000 is given to the pro bono program and $30,000 to the Pro-Per program, because the pro bono program, the main fund, rarely utilizes the entirety of the $270,000 allocated to it, language could be added to the statute to allow for a transfer of the non-expended funds from the pro bono, the main fund, to the Pro-Pers. If they did that at the end of the fiscal year, which would be June 30th, then that would allow any excess to go into the Pro-Per while there was still 6 months of time to get it out in that current year. So that overlap would actually work in our favor. That would also require an increase to the 30,000 cap for the Pro-Pers. Those are legislative changes that we would ask for help with. By doing that mid-year transfer, we would be able to help many more Pro-Per litigants. They would be able to receive that assistance without adding any added burden to court reporters through higher fees. It would also reduce the backlog that historically accumulates in applications from March through December. So it's a win-win situation for everyone. The board notes that there is a legislative staff recommendation for the committees to require the board to establish a review program to verify the financial status of applicants, to ensure that the recipients of the Pro-Per funds are deserving of those funds. As I mentioned, on the pro bono side, the main fund, those applicants are vetted through the pro bono attorneys. So if that were to come in-house to staff, I think that would be very, very difficult to actually try to put procedures in place to verify the financial status of an applicant. However, to ensure the best use of the fund, I think it would be a good idea for the board to seek to prohibit vexatious litigants from having access to the fund. And I'd be happy to answer questions on those two issues, or we can move on to the next issue.
Why don't we move on and we'll take the questions at one time.
Very good.
So I took on issue number 3. Should an extension be granted to continue the TRF for indigent litigants? The board agrees with legislative staff analysis that it's a valued program serving the most needy in our community to receive access to justice. It has helped countless indigent litigants obtain transcripts necessary for their litigation, reimbursing more than $8.5 million in transcript costs to date, as mentioned earlier. Again, the TRF is funded entirely from license fees using no general fund money whatsoever. As it was stated before, the board really sees it as a win-win for the various consumer interests involved. There are multiple interests. The board also sees no harm in the staff recommendation to delete the sunset date for the Pro-Per program, thus reinforcing that it is one program funding 2 types of applicants. Clearly, it should be noted that this is hampered if there are funding issues that we've been discussing that are not resolved. With that said, the board in its due diligence has also evaluated other alternative funding sources for the TRF that are not tied to the license fees. The board has been unable to find an alternative source after that evaluation. The state's general fund is already stretched to the maximum. Attorneys already have the option for a portion of their license fees to go towards the bar's pro bono efforts. The Judicial Council could match funds, but it's constantly seeking cost-saving measures and greater efficiencies, and they too are stretched with their budget thin. All in all, the current situation is appropriate And it's important to note that court reporters are completely willing to fund the TRF via license fees, knowing that ultimately these funds will be paid back to them in the form of reimbursement for transcripts, and clearly the qualified indigent litigants who receive the necessary transcripts at a no or low-cost benefit.
Hello, my name is Rosalie Crom. I'm vice chair for this board appointed by Governor Brown. I became a licensed court reporter in 1981, and I started my corporation or my court reporting firm in 1985. And I am to speak to issue number 4. Is the board able to enforce court reporting statutes against foreign court reporting corporations? The board has had a long journey in its quest to ensure all companies offering court reporting services obey the same laws and regulations governing court reporting, starting with convening a task force to explore the issue in 2007. In 2009, the board supported AB 1461, authored by Ruskin, which would have clarified that any entity offering court reporting services was required to comply with all laws governing court reporting. That bill ultimately failed. In 2010, the board received a complaint against a foreign corporation for violation of gift giving. After an investigation, a citation and fine were issued, but the foreign corporation the foreign corporation denied the board's jurisdiction. In 2011, the board brought suit against that foreign corporation, seeking declaratory relief. The court in that matter found that although the corporation was rendering court reporting services in California and was indeed in violation of the gift-giving regulations, there was no explicit authority in statute authorizing the board to impose citations or fines against a foreign corporation. The heart of the problem is with the board's jurisdiction over these corporations. Corporations Code 13410 sub A requires professional corporations, defined as those that provide services for which a license is required, be subject to the same rules and regulations as licensees. So while both the Corporations Code and the Business and Profession Code are clear that licensees and professional corporations must be held to all the rules and regulations applicable to the practice of court reporting, the corporations in question claim that they are merely arranging for court reporting services and not providing them, therefore are exempt from following the law. This would mean pursuing an injunction against each corporation, and the court would need to determine on a case-by-case basis if that corporation were providing court reporting services. Clearly, a decision of this financial magnitude would need to be analyzed carefully in conjunction with the Attorney General's office. The board has been exploring many options, and we find ourselves listening to people who are very passionate about their positions on the best course of action. It's the board's job to sort through all of the input and make decisions based on what is ultimately best for the consumer. Which brings us to SB 270, a bill by Mendoza. This bill has been amended to include firm registration, which, if implemented, would assist the board in enforcement efforts regarding court reporting firms. This would not be a complete change for the industry, as the board had registered firms until the early 90s, when it was decided registering with the board was duplicative of the filing requirements of the Secretary of State. For many years, there were no issues, but increasingly, if there were problems, the non-licensee-owned firm points the finger at the court reporter, while the court reporter points the finger at the firm that hired them. We have corporations that are overbilling, reformatting transcripts to increase the cost to the litigant, cost shifting, wherein one side unwittingly and unknowingly ends up funding the litigation costs, as well as indulging in excessive and unethical gift-giving. Because the noticing or hiring attorney for a deposition or hearing chooses which court reporting firm to hire, the other parties in the case have no say in what they will be charged or how they will be charged, and thus cost shifting may come into play. Court reporting in California is a multi-billion-dollar industry, making it attractive to large out-of-state firms owned by non-licensees. Like other pro-business stakeholders, the board welcomes these business owners. That being said, those businesses may not come in and do whatever they want to the California consumer. It is imperative that they be held to the same standards set out in California statute and regulation. I think it's common sense. The board's job becomes difficult and complex when there are multiple consumers with, at times, competing interests. Certainly when there are opposing viewpoints, there is no way for all sides to win, but the board is striving to help all interested parties work together to achieve the best possible outcome for the consumers. The passage of SB 270 by Senator Mendoza would greatly enhance the board's ability to protect the California consumer from practices outside the law.
So in closing, court reporters play an essential role in our judicial system as a neutral third party who creates verbatim transcripts of proceedings in a timely fashion, thus ensuring the appeal rights of all litigants. All of the board's work ultimately goes to ensuring the vision that consumers are able to hire a California licensed court reporter of the highest quality, knowledge, and ethical professional disposition. The board truly embraces its consumer protection mission and has worked hard to manage our scarce and limited resources into the most effective and efficient operation possible to see this vision through. The current board members are actively engaged in their regulating and policy-setting duties, as well as the enforcement matters that rise to their level. Thus far, the board is balancing competing consumer interests, as it's been noted, and finding solutions to this evolving industry. The board concurs with legislative staff's assertion that the health, safety, and welfare of the public are better protected by a well-regulated court reporting profession. The board is truly committed to the mission it was given by the legislature 65 years ago, and looks forward to working with the legislative staff to address any concerns it may find arising out of this review. The board respectfully requests the legislature to allow the court board to continue its dedicated oversight of the court reporting industry and stand strong in defending the record.
Okay, thank you, Ms. Hart. I have some questions, but we'll move to the, yes, no, after you, Senator Mendoza.
Just, I know you made reference to the bill that I'm carrying, and it's in the assembly side right now. Given the problem that is existing there without a state corporations coming in and providing these services, what tools would be helpful for the board to be able to address this issue, this problem?
Thank you for the question, Senator. I think it's really key that whatever avenue the board decides ultimately is going to be the best road forward, what we're trying to do is level the playing field. The consumer doesn't know, the average consumer maybe comes into contact with a court reporter once during their lifetime. Maybe they go through a divorce, or maybe they're involved in litigation one time. So it's not a case of a very savvy consumer that comes forward. So for that reason, I feel like the board needs to be extra vigilant. We need to make sure that the court reporters know the law. They need to make sure that the consumers are being treated fairly and equally. And so for that very reason, all of the firms that come into California need to be following all of those rules and regulations. How we get there is a little bit tricky. I think the bill that you have introduced is going to go far toward helping us hold everyone to the same standard.
I know the bill is currently in the Assembly Committee, and we're waiting for to hopefully be taken up again. Does the bill, the way the bill is drafted, would that be helpful to what you're trying to accomplish right now, as far as regulating these out-of-state corporations that are doing gift giving and other practices that are illegal, ethically illegal here in California, but they're able to do it because they come here just to would you say, you said something like either they're here to facilitate, but they're not here to actually do the job?
Yeah, their assertion is that they're not providing court reporting services, they are merely arranging for it.
So that by doing that, they're able to do gift giving and other unethical practices that we don't condone in our state. Exactly. Would the bill, will SB 270 be able to address the concerns that you are trying to?
That's our analysis. The board will be meeting in April to discuss the issue further and have a formal position.